partner and financial advisor of Metropolitan Wealth Advisors, James M. Lee, chartered financial consultant, has been recognized for showing dedication, leadership, and excellence in wealth management. James has almost 3 decades of experience helping people tackle everyday financial goals such as planning for retirement, reducing taxes, life insurance, estate planning, and asset management. He has received the 5-Star Wealth Manager Recognition Award. James will be presenting today on the subject, Estate Planning, a Sensible Approach, which begins with the question, what does estate planning mean to you? James will cover the 5 documents he believes are critical to every estate plan and will conclude with a discussion on how to avoid the 10 common mistakes people make with their estates. Please join me in welcoming James Lee.
Well, thank you, Patty. Everything sounded pretty good until you went to the 3 decades. It's kind of hard to believe, but with that, we have a lot of information to go over in a very short period of time. So please bear with me as I go right through this, and then we'll be able to answer questions at the end. As I usually do in video presentations, during the actual presentation, I hope you all don't mind, but I usually turn my video screen off. Don't want to be a distraction to anybody. So I'm going to go ahead and turn that off, and then we'll get going. All right, before we begin, one thing that's very important is that although we're providing this information here in conjunction with University of Maryland, and thanks to John for always inviting me to be a presenter, I am available and my team is available to answer any questions that you have. So if you're not able to ask your questions during or after the workshop, then you can always feel free to reach out to us, and we are here to answer any individual questions that you may have. So what does estate planning mean to you? That's something that we're going to discuss, as well as today's estate tax landscape and how to avoid 10 common estate planning mistakes. But the question, what does estate planning mean to you, obviously is very different for different individuals. It really depends on your situation. In the past, many people thought of estate planning as something that's only for the rich or the wealthy, but that couldn't be further from the truth. When it comes to estate planning, it's really about organization. So we can look at situations like determining who's going to care for your children. What about structuring your finances and strategizing the best way to minimize costs to make it more efficient so you're not paying more taxes than you need to? Establishing who will handle your finances, that's a very important one. And deciding who's going to make medical decisions on your behalf, as well as determining if your beneficiaries can even handle the estate if they were to receive it as a lump sum. So really, from an organizational standpoint, everyone needs some level of estate planning. Everybody. It doesn't matter how young or how old you are. You definitely need to do something. So in this example, we can look at parents with financially irresponsible children. I think that most of us hope to believe that our children will be responsible. But the one thing that I can tell you from past experiences and dealing with many, many estates is that, well, once the situation happens, somebody passes away and the money is presented, it doesn't always play out the way that you envision. Spouses with children from previous marriages or grandparents who want to benefit and make sure that their grandchildren are protected, or at least their inheritances, business owners that want to pass assets, and of course individuals who are leaving assets to those with special needs, because it's very important that you don't leave assets directly to them. So let's look at today's estate tax landscape. So from 2011 to 2012, it was 35% as the top federal estate tax rate. From 2013 and beyond, it went up to 40%. Now, what does that mean? That's the tax that you would pay that is above and beyond the federal exemption. So what is the federal exemption? Today, it is $11,700,000 per person that you can leave, or $23,400,000 for a married couple that you can leave without paying any federal estate tax. Now, let's not confuse that with income tax. This is the federal estate tax. And you may look at this number and say, well, gee, as a married couple, 23,400,000, I think we're good. I think we're good. But you just have to understand that when you look at those numbers, that is today. That is not necessarily what's going to be the case in the future. So we can definitely imagine in the years to come that that number will come down. And it's very possible. I mean, if we look back to 2006 and before, the federal exemption was only 1 million. If you can believe that. So anything above $1 million, you paid federal estate taxes if you passed away. Now let's look at the other taxes that are out there when one passes, and it depends on what state that you live in. So in this example, we'll look at the state of Maryland. So the wonderful state of Maryland, where I was born and reside, we do have an estate tax and an inheritance tax. So some states just have an estate tax, some states just have an inheritance tax, and here we have both. So when looking at an estate tax, they have an exemption as well, which is 5 million. So again, what does that mean for Maryland? What that means is that if I have, as an example, if my estate is 7 million and I were to pass away in Maryland, anything above 5 million, so the 2 million, would be subject to a state estate tax. An inheritance tax only applies to non-family members or non-direct lineage. Okay, so if I were to pass away and I left something to a cousin or a friend, in that situation, they would pay a 10% inheritance tax as well. So let's look at 10 common estate planning mistakes that we see most often. The first, as you can probably guess, is failure to make a plan. It's always very important as part of the organizational process to make sure that you put a plan together. But the problem is a lot of people fail to put a plan together because number one, they might be overthinking it, and number two, they just can't decide on certain details. But the one thing that I would encourage you to do is to at least get something done. You can always change it in the future. That's not a problem, but you certainly don't want to delay getting something done because of a few decisions here and there. You want to avoid assets passing to the wrong heir in the wrong way. You know, you may have certain things that you want going over time or in a lump sum, depending on what your heir situations are. And of course, working with a team that includes a financial advisor, tax professional, estate planning attorney to make sure that all bases are covered. So let's look at documenting your wishes. What am I going to use to do that? We have the will, healthcare power of attorney, your durable financial power of attorney, living will, and your HIPAA release. So let's look at the will. What is a will? A will clearly tells the probate court, of which you're going to take the will to, who your rightful heirs are and any specific possessions or assets that you have that do not have a beneficiary designation, who they're going to go to. And you also name a personal representative or an executor for the will itself and a guardian for minor children. So that goes in the will. So you're in the will, just remember, it tells the probate court who my rightful heirs are. If you do not have a will, then the probate court has to determine who those rightful heirs are. And that can be costly in some circumstances. Surviving family members often fight over things, not money. And I can tell you from personal experience that I have 3 children, and my daughter has already state claim to certain things that it better not go to my daughter-in-laws. And that's something that if you want specific items to go to specific children, then that's something that you would put in the will. So anything that, it's all about setting a direction, really. That's what it comes down to, is you want to make sure that everything or all of your thoughts are actually in writing. So what does the executor or personal representative do once somebody passes? And, in going through this process, the one thing that I want you to consider is, as people are stating who, when they're developing the will, they pick, well, who's going to be the executor of my will? Well, I'll make this person or that person. For all of these documents, I do want to say that you should definitely have one person who's the primary executor and at least two contingent, okay? Because if the first person can't do it, whether they physically are not unable to do it, maybe they live too far away, who knows what the situation is? Maybe they don't want to do it because it's a lot of work. Then that allows the second person to take over. The one thing we generally don't recommend is to have co-executors, just because in some circumstances they can have disagreements in the way that things should be done, and it could create a little bit more of a mess. So again, we want to document everything, have it in writing, and our personal executive or representative, their job is just to follow the instructions that we left. So what are they going to do? They're going to submit the paperwork to probate. They take inventory of assets. So you have to make sure that you have a full list of everything that the person had who passed away. And in some circumstances, we know that, and you may know somebody who's been through this or been through it yourself, that if you're not sure about all of the assets, then you really literally have to wait for mail to come in to see what arises. You have to notify creditors because they have to be paid back, of course. With any debts, any other debts and expenses, you distribute property per instructions in the will, and then you submit paperwork to close out the proceedings. With the healthcare power of attorney, you have a representative, and that representative will make healthcare decisions for you. And when you look at choosing your healthcare representative, in some circumstances, it does help if it's somebody who's a little bit more local or has experience or some experience when it comes to healthcare itself. You don't have to have the same person as the executor of your will and your healthcare representative. It can be completely different people. And then you have the power of attorney. So the durable power of attorney is an extremely important document because it's relevant while you're alive, not when you pass, while you're alive. So I've always heard of people in the past, they said, well, I keep a joint account with my parents, or parents saying I keep a joint account with my children. Oh, why do you do that? So they have easy access in case something happens to me if I'm in the hospital and they need to pay bills or something like that, then I have a joint account with them. But that's actually the last thing that you should do. You do not need joint accounts with your parents, or if you're a little bit older and you have it with your children, you just don't need that. All you need is the power of attorney documentation. Because with that, anyone that you assign can make financial decisions on your behalf, and yet they're not joint on an account with you. And the significance of that is that if I have a joint account with my parents, okay, they have a brokerage account, a savings account, whatever, and they have me on their joint for ease, all right? Well, let's say I get into a car accident, I'm sued, they go after all my assets. Guess what's part of my assets? The joint account that I have with my parents. So even though the odds of something like that, or something that will that could be subject to liability, you never know, right? And it's just completely unnecessary. But also from a tax standpoint, you have to think of it in terms of this. If I have a brokerage account with my parents and it's joint, then that's the worst way to inherit money. Because right now, whatever growth that there is, if I inherit the funds, then I get what's called a step up in basis. So that means that the date of death is my new value, my new starting point. So if I sell it right away, I would pay 0 taxes. But if I'm joint on the account and they bought something at 10 and it goes to 100, well, that 90 gain, half of that I would have to pay taxes on. So it just all the way around, it really just doesn't make any sense to be joint. All you need is the power of attorney documentation. And then there's the living will. I can tell you I have personal experience. This past summer, my father passed away, and he had been in the hospital multiple times. He had, you know, really, really difficult situation. It wasn't quick whatsoever. But with the living will, it states very clearly, and it allows you to dictate whether you want to be kept on any level of life support or not. Believe me when I tell you, having been through this, and I have 3 sisters, of which, you know, we're all there together, but I'm the representative for the living will, so I simply follow the instructions. Because when the time comes, people are very emotional, and there's a lot of difference of opinion. But you can save your family the headache of trying to determine what to do by simply putting it in writing, and your instructions should be followed. The HIPAA release form, of course, is necessary in order for your representative to get medical information so they can show it to other physicians, make hospital changes, whatever the case may be. So again, making sure that you document your wishes. These are the primary documents that every one of you absolutely need to have. There's not one person that shouldn't have these 5 documents here. And as you go through life, you will make changes. That's the expectation. It's definitely going to happen. But you'll feel much more comfortable once you have all of this in place. Heath Ledger, I'm sure many of you know, he was from the Dark Knight. He had a will, but it was done before his daughter was born. So his estate actually went to his parents and his sisters. And after much deliberation, it literally took 5 years for them to finally say, okay, well, we'll go ahead and give the money that we received from Heath to his daughter. So keeping your documents up to date are definitely very, very important. Setting up guardianship is probably the single most difficult thing that I see for people when it comes to getting your will together. I know when I did it with my wife, with 3 young children, I mean, my children are grown now, but with 3 young children, it was quite a debate of as far as who was going to be the guardian of our children if something were to happen. And I just want you to remember that the executor of the will, the person who handles the money, doesn't have to be the same person who has guardianship for the children. It could very well be 2 different people. Okay, so you can set it up whichever way that you like. But as you can imagine, the guardian is the person who is going to take care of your children, so they will need some level of money, and that is something that can be put in the will as well, as far as how much money can be dedicated for the children and what types of items would be paid for. One side note that I want all of you to remember when it comes to the will itself and the importance of a will. In the state of Maryland, if you pass away without a will, now these are probate assets, so it doesn't include things that have beneficiary designations like life insurance or your 401k or your IRA. Anything that does not have a beneficiary designation, okay? But if you die without a will and you have a spouse with children who are minors, by law, the interstate law of Maryland, the spouse inherits half of your interstate property and the children inherit everything else. You would have thought everything just goes right to the spouse, right? Not in the state of Maryland. You have a spouse and descendants, but none of them are minors. The spouse inherits $15,000 worth of your interstate property plus half of the balance, and the descendants inherit everything else. So you get an extra $15,000 if you're the spouse there. But what if you're a spouse but there are spouse and parents, but no descendants. The spouse inherits 15,000 worth of your intestate property plus half of the balance, and the parents inherit everything else. Isn't that interesting? Everybody should have a will, for sure. Now let's talk about trust. So why should I have a trust? What's the difference? A lot of people, unfortunately, when they hear about trust, they think it's some tax sheltered account or something that, you know, wealthy people use, something that's real obscure, but it's really pretty straightforward. If it's a living trust, then it really doesn't do anything for you while you're alive. It really goes into effect when you pass away, and I'll go into that a little bit. Let's move on to some of the benefits of the trust. So beneficiaries can gain quicker access to the estate. So here's what happens. If I have a living trust and I assign assets to the trust, so they can be in trust name, which doesn't really do anything for you right now, contrary to what some people may believe, because it's still under your control. But when I pass away, my trust becomes irrevocable, and it would have a separate tax ID number. So now it's completely out of my estate, and now it's a separate tax entity. So as a result of that, in some circumstances, people in the past have used different trusts to reduce the amount of estate taxes. It can help you retain control of assets for the heirs. It can protect your legacy from creditors, and it passes outside of probate. So why are people utilizing trusts right now if the estate tax exemption is so high? Well, the number one reason why I see our clients utilizing trusts is because they want to protect their assets for their lineage, which means their children and their grandchildren. And I'll give you an example of that. I have a trust, a living trust, or an irrevocable trust. In either case, when I pass away, both are still irrevocable at that point. So now I pass away, and all of my money is in this trust. And even though my children are trustee, they can access those funds at their will. But the bottom line is, that's a separate tax entity. It is not theirs until they take the money out. So if they were to get divorced, that money is not theirs yet, so it cannot be attached in the divorce. If they were to be sued, that money is not theirs yet, so it's not included. So that's the level of protection. And I'll be honest with you, most people who are doing it are thinking about the divorce factor, because they want to make sure that an ex-in-law can't attach any of those funds, that whatever's there is going to go down to grandchildren and their lineage beyond that. So that's a primary reason why I see people doing trusts. But beyond that, it's about control. Control is very important. If you want to put any stipulations in your estate, such as you don't get any money unless you visit my grave at least once a month. Well, if you want to put that in your trust, you can do that. If you want to limit the amount that any heirs can receive at any given time, sometimes I see people splitting the estate into thirds, that they get 1/3 in their 20s, 1/3 in their 30s, and 1/3 in their 40s. However you want to dictate how people receive money, you would utilize a trust to do that. So in setting up a trust, you have a grantor, that's the person who sets up the trust. Then, of course, you have your beneficiaries, the people who are recipients, and the trustee, the person who's going to handle everything within the trust. One thing of note, if I have a lot of stipulations in my trust and one of my children is the trustee, when I pass away, the three of my kids, I can actually envision this, getting together and saying, you know, it's just the three of us, so why do we have to follow any instructions as far as restrictions go? Let's just go ahead and take everything. And likely, that would probably be the case, especially with my children. So if you're going to have restrictions, it's usually better not to have one of the interested parties as trustee. Otherwise, there's nobody to police those restrictions. So when it comes to trusts, there are a lot of trusts that are out there, your bypass trusts. I'm not going to go into each one, but depending on what you would like to accomplish, there's certainly a trust that fits your situation. So again, when it comes to why you should have a trust, it allows you to keep control. Sometimes it's easier, it keeps everything in one spot. And of course, ease of access is extremely important. So when it comes to federal and state estate taxes, there is a process and there is a timeline of which it needs to be paid. So federal estate taxes are due within 9 months of death. Obviously, you have to pay them not in cash, but by utilizing a check. But at the end of the day, they do not mess around when it comes to collecting their money. So liquidity becomes extremely important. We see situations where people are leaving primarily property and it takes longer than 9 months. You can, ask for an extension, but liquidity does become an issue. So if you have a situation where you have primarily, real estate or non-liquid assets, you really should look at other things. I mean, some people utilize life insurance, some people investments, whatever it may be, but you need some liquidity there in order to at least pay whatever expenses may exist so you don't have to sell properties right away, maybe at an inopportune time. And then there are strategies that you can take to reduce the amount of your estate tax. So how do I avoid probate? Probate's the legal process that verifies your will through courts. And we had just, talked about the probate process, and it can be slow in some circumstances. Again, with my father, I did go through the probate process. Thankfully, I had his estate fairly organized. And so it was really pretty straightforward, to be honest with you. But then I also hear about a lot of other situations that are just nightmares because, again, of the disorganization. That's ultimately what it keeps coming down to. Long-term care is something that is real. When we look at the statistics of long-term care, there's a likelihood now, they say, of 1 in 2, so 50%, that through your lifetime, 1 in 2 people will need some level of care, whether it's in the home or whether it's in a facility. But in either case, the one expense that can really derail a family's retirement is long-term care. Because the issue is you may have enough funds that you've saved, enough funds that are invested, to pay for long-term care. But really the issue that we see more often than not is that one spouse needs care. They need care longer than expected, whether it's in the home or in a facility. And that spouse who needs care eats up all of the liquid funds that are available, and now there's not enough for the other spouse. So when it comes to long-term care, one thought is if you look at long-term care insurance, if you're whether you have a spouse or significant other, it may not be necessary for both of you to have long-term care insurance. Maybe it's just one of you. Because again, you want to make sure that there's enough left over in the estate to cover the other person. So just a thought there. Number 8 is the IRD, income in respect of a decedent. So if you didn't pay income tax on accrued income, your beneficiaries will have to pay money on that. So what does that mean? Leaving funds from a qualified account are the most inefficient way of leaving money. Okay, when I say qualified account, what I mean are retirement accounts, 401ks, traditional IRAs. What we see happen is this. People go through retirement, they have their money in their 401k, they don't really need the money, so they just take minimal amounts out, or they don't take anything out at all until they hit now 72 years old and they have to take required minimum distribution. Now they only take required minimum distribution, they don't take any more than that, and the account, because it's performing well, stays steady or even grows. That's fantastic, right? until it goes to your children. When it goes to your children or your heirs, then all of that money is 100% income taxable on top of their employment income. So even if they were to say, you know what, I'm not going to take it as a lump sum, I'm going to stretch it. Now the rule is 10 years. So you have to empty out that retirement account over a 10-year period. And if you have, $1 million in there, that's $100,000 a year on top of their income. So it's likely to be taxed at the highest tax bracket. So one thing to think about throughout your retirement is, do I really want to leave my retirement accounts to my heirs? If in some circumstances throughout your retirement, you may be in a lower tax bracket in your retirement than your heirs are right now because they're doing well. So if that's the case, it's better for me to take money out, even though I don't need it, and reinvest it, than to leave it to them and have them pay it at a higher tax bracket. Because again, why pay more taxes or have more taxes taken out of it than needs to have happen? And the worst part is, I don't see people stretching it over 10 years. In every economic situation, irregardless, I see people taking lump sums and then paying 40+% in taxes on the money that's inherited. So something to be aware of, that you really, if at all possible, want to reduce the amount that you leave to your heirs in traditional 401k or traditional IRAs. And one way that you can change that up a little bit is, if you're still employed, you can contribute to the Roth 401k, or if you have an IRA, you can do small conversions each year into a Roth, or you can make Roth IRA contributions if you are below a certain income tax level. And then, of course, there are insurance policies. What's interesting is, when it comes to insurance, most of us think of insurance as, well, just replacing our income, right? That's what we want to replace, is our income while we're working. But actually, a vast majority of insurance that's purchased out there is really for estate planning. And the reason why is because by obtaining a permanent insurance policy, that's a guaranteed amount that's going to go to my heirs. So that's number one. Number two, it goes to them tax-free. Now, it is part of your estate. So if you have a $30 million life insurance policy, then yes, it's going to go over the limitation of the 23 million, okay? It is part of your estate, but the proceeds are income tax-free. So it's immediate liquid funds that go to your heirs that they can utilize to pay any taxes or expenses, so other assets don't need to be sold. That's the efficiency of utilizing life insurance in your actual estate. So what we see a lot of people do is, if you know you're going to leave significant assets and investments or whatever the case may be, I see people taking some of the gains from their investments and diversifying it by putting that into a life policy, which leaves a guaranteed death benefit. So just another way to diversify your assets to keep it a little bit more efficient. And then making sure your beneficiaries are up to date. So the beneficiaries that you have on your life insurance, your 401k, other retirement accounts, whatever the case may be, they all bypass your will. So if my will says everything goes to my wife and my children, okay, great. But my IRA, my beneficiary is my sister. When I pass away, where does that go? That IRA goes to my sister, okay? So it's extremely important to make sure that the beneficiaries that you have set up align with your will, or whatever's done is done with a reason or purpose fully, okay? Not only that, any accounts that you have, whether they're savings accounts, brokerage accounts, anything that does not have a beneficiary designation financially, you can put one on there. So you can go to the bank, ask for a TOD or POD that's payable on death or transfer on death. It's one document, and you list your beneficiaries, and boom, it's on your account. It's that easy. So if you were to pass away, your beneficiaries could just go in with a death certificate, claim form, ID, and their portion is theirs. It's that easy. It's that easy. So that's something that everyone should do with any accounts like that, savings or non-qualified brokerage accounts. You definitely need to have a payable on death or transfer on death for sure. So please make sure that all information is updated, including contact information when it comes to your beneficiaries. And lastly, and something that's fairly new, is don't forget about your digital assets. So a lot of people don't think about this one. Because of all of the accounts that you have online, who's going to close them all down? And how do they have authority to do that? So that has to be included in your will or your trust, okay? Because you don't want to have open accounts out there. I mean, that's a thing nowadays, is they take over accounts of the deceased and they do whatever it is that they want to do for fraudulent behavior. So please make sure that you don't forget about the digital assets that are there and that you assign it so they can go in and take it over, because there may be accounts that you have that have pictures or documents that you want to maintain, that you want to make sure don't get lost, and you want to make sure that people have accessibility to that. So when you do your documents in the state of Maryland, you'll find that you don't need an attorney to do your estate documents when it comes to your will. If you want to do it on a piece of paper and have two witnesses, I'm not recommending that you do that, but it can be done. If you want to work with an attorney in order to get these documents done, that's usually what's recommended, but it depends on how simplistic your situation is, because there are the online documents that are available as well. And if it's a very simple, straightforward situation, you could very well utilize those online services. But while you're doing that, you just want to make sure that all of these documents that we had gone through are actually included. You don't want to leave anything out. And again, you want to make sure that the digital assets are covered in those documents as well. So with that, we have gone through the 10 common mistakes that are out there. I know that it's a lot, and I kind of sped through this. Usually this presentation actually lasts close to an hour and a half, and we consolidated it very much in half. So we did have to go through rather quickly, but I am available for you to answer any questions that you may have, whether it's in this forum or my email is here at jlee@metwealthadv.com. One of the agreements is my team is readily available to answer any questions that you have. So if you do have any questions pertaining to your individual situation, please feel free to email me, and we will be happy to get back with you and have a personal call if necessary. So with that, I'm going to open it up to any questions that you may have.
So thank you, James, for that wonderful presentation. It was loaded with information. We have a lot of questions flowing through, and hopefully we will get to all of them. And if not, James has given you his email address so that you can follow up as needed. A lot of people have been asking about the recording. It will be available, I believe, after the virtual conference today. But let's get to the first question, which is, how would you find a reputable estate planner and attorney, and someone who will help you start that process, James?
That's a good question. Reputable. There are other presenters that are part of this Wills Week, so that's something that they could probably help you a bit more with, because they're exactly in that industry. But really all that we can do is research as much as possible, like any other service that we hire. Really is, we're looking for reviews, recommendations, referrals, whatever the case may be. If you have a financial advisor, then it's likely that they know someone or work with someone. And if not, if you don't have that personal connection, then yes, it's just a matter of doing research, really. But the one thing that I caution you on, because I do work directly, I'm the quarterback of the team. So I work with the attorney and the clients. And I just caution you that sometimes you don't need 500 documents, maybe 20 is enough. And I'll leave it at that.
Okay, thank you. Our next question is, can you tell us the difference between a trust and a living trust? And should you reference the trust in your will?
Okay, that's a good question. So let's get away from whether it's a living trust versus a trust. So if you can imagine this, the trust is like a shell. Okay, so this shell, you can have any kind of nuts inside of that shell, right? It just depends on your situation. Now, how that shell is going to work is going to vary. So there are different types of trusts. It's not just trust in general. There isn't just a trust. It has to be a type of trust. So the living trust goes into effect once you both pass away, or once one spouse passes away if you're married, okay? So while I'm alive, the living trust is really just an empty shell, really. I mean, there's no tax benefit. It doesn't assist you in any, it doesn't protect assets. It doesn't do any of that. But once I pass away, it becomes a separate tax entity. Once that happens, then that's a whole new ball game because that's outside of my estate. Now, going back to the different types of trusts that are out there, it goes back to what I had here. I'm gonna back up. Oops, let me see here. That slide where I listed all of the different trusts that exist, you know, if you want to have everything out of your estate right now, then you could do an irrevocable trust. So what does that mean? An irrevocable trust is a trust that has a separate tax ID now, okay? And what I can do is I can transfer my assets to this irrevocable trust to take it out of my estate. So if I wanted to move assets out of my estate that are going to appreciate a lot, I'll give you an example. Let's say I had shares of a business and my business was booming. I could take shares of my business and put it into an irrevocable trust. So now this is outside of my estate. So if that grows to 100 million outside of my estate, then when it goes to my children, it's not part of estate taxes. So I'm taking it out of my estate now, out of my assets now, as opposed to waiting till after I pass away. But the bottom line is there are many different types of trusts. So you have to pick the right trust that fits what it is that you're trying to accomplish. Because ultimately that's what it comes down to, is what am I trying to accomplish?
Thank you. Our next question has to do with spousal roles and some of the tax exemptions. So is it recommended to name your spouse as an executor? And is the 5 million exemption for each spousal member, meaning a total of 10 million?
Yes. Whenever we speak of exemptions, it's per person. Okay, so every exemption is per person, and normally with wills and trusts, the spouses are the executors or trustees. That's how we normally see it.
Great. And then this is a little bit of an acronym, but what is a POLST, which is a physician's orders for life-sustaining members? And is it needed? Or is it recommended?
Well, that's where the living will comes in, because that's all about life-sustaining measures. So within the living will itself, you'll have an opportunity to clearly state whether you want to be kept on life support, whether you want to be fed through a tube or not fed through a tube, to what extent you want to be kept alive. That's really what it comes down to. Because again, I just went through that experience with my father, and there was a very specific time frame that he had listed that he would want to be kept on life support. And to be honest with you, we honored that. I mean, and then there are people in my family who did not want to honor that. But that's the importance of having the living will, so you can dictate in detail how you want to be handled, and to direct those that you assign as your representatives to abide by that.
Thank you. And related to that question, would you recommend that a person assign that to their spouse in terms of the health care and financial power of attorney? Or if you don't recommend a spouse, who might be some individuals that you recommend?
Well, again, generally we do have our spouses as primary, generally. But remember, with every one of these documents, you need to have a primary representative, and you need to have a contingent and another contingent. So as power of attorney, I'll give you an example. Let's say my wife and I are traveling outside of the country, and we're stuck for whatever reason, okay? And we have things that need to be taken care of here financially. Well, the second person in line can take those documents to the bank and with their ID and show, look, I'm contingent and with a letter from the primary saying that they're not able to do it, and they could actually execute financial decisions on your behalf. So that's why we always have to have a primary, a contingent, then another contingent, just in case the people in front aren't available to execute the documents.
I may even know the answer to this one, but one of our participants has relocated from the state of Maryland to Florida. And so the question is, should he or she get his or her will redone in Florida?
Yeah, that's a big one. There are a lot of people that don't. And because, at the end of the day, when you go to the probate court, whether it's in Florida or whether it's in Maryland or whether it's in Pennsylvania, whatever, probate court's probate court, okay? So the documents that you're taking is just stating to the probate court who the rightful heirs of your estate are. Now, if there are any stipulations within your will in itself that could be affected by other state laws, in the way that people inherit things and that sort of thing, then yes, there's some changes that could be made. But those are usually small changes within your overall documents that may be state specific. But overall, there are plenty of people that move to different states and never update their wills, and they still can submit it to the probate court, because once I do my will and all of those documents, it's not as if I'm taking it to the state of Maryland and they have it on record and that's what has to show up. No, that's not it at all. It's my document. I take it with me wherever I want.
And then can you quickly discuss in terms of the difference between a trust beneficiary as opposed to leaving assets to a specific person?
It's one and the same. Whether you identify a specific person through whatever source it may be, such as a retirement account, I can split beneficiaries 10 different ways if I want, and name a specific person and a certain percentage or a certain dollar amount. So you can be very specific whether you're using a beneficiary designation or whether you're using a will document to state who the beneficiary is and the percentage that they will receive. So you have all the control to do that in any capacity that you like, using the will or just a beneficiary designation.
And can you quickly discuss the difference between a traditional IRA and a Roth IRA?
Very, very important. So a traditional IRA, the funds that I contribute are pre-tax. So I do not pay taxes on the money that I put into a traditional IRA or 401k. If you're working, you know it comes out before you pay taxes. When do I pay taxes? I pay taxes when I take the money out. Okay, that's a traditional. Now, the idea is, and here's the problem with the financial world and every bit of information that they've been providing throughout the years. The assumption always is that when I retire, I'll be in a lower tax bracket than I am today. So I don't want to pay taxes today. I want to pay when I'm retired. But nobody ever asks the question, do I really want to be in a lower tax bracket when I retire? Because that means I don't have that much money coming in. I don't want to have that. It may be the case, yes, but I don't want to have that. But what we have now is we have people that did a very good job of saving, and then when they retire, they're forced to take money out and it's all taxable. So they're in the highest tax bracket of their lives in their 70s and 80s. That's what's happening right now. So let me back into a Roth. The Roth, the money I put in is after tax. So I pay taxes and then I put the money in. But here's the thing, it grows tax deferred. And when I take the money out, it comes out tax free. So if I have accumulated hundreds and thousands of dollars in a Roth account, even though I know I pay taxes in the beginning, when I retire, if I take 100,000 or 200,000 out at one time, you know how much I pay in taxes? Zero. So it's something that, quite honestly, every single person should have, and you'll be glad that you have it, to have some tax-free money available to you.
Our next question is, if children are named a beneficiary on the IRA or the 401k, do they have to still deal with the IRD issue?
Yes, it doesn't matter who the beneficiary is. Income and receipt of a decedent is always there. The bottom line is, no matter who the beneficiary is, taxes need to be paid unless it's a nonprofit, because of course they don't pay any taxes. Mm-hmm. So if it's a charity nonprofit, then they don't have to worry about that on their end. But anybody else who's taxable, yes, they will pay taxes on the funds that they receive from you.
And can a transfer on death be completed for your home?
Yeah, that generally is done through the will. That's what most people do, is they would put the home in the will. So, and there are versions of that, that you can do, but by leaving it in the will, here's the bottom line. The home is an asset, so you get a step up in cost basis. So if I buy my home for $100,000 and I sell it, and it's worth $500,000 when I pass away, well, by leaving it to my heirs through will, okay, then if they sell it the day after I pass away, they pay zero in gains, zero, okay, because it's called a step up in cost basis. But that's why I wouldn't want to be joint with my children on that, because if they were joint with me, that gain, they would have to pay taxes on part of that gain. And, by the way, I just want to back up Patty real quick. University of Maryland is one of those places that you could leave money to and they wouldn't pay any taxes. I just thought I'd throw that in there.
Exactly. Thank you so much for the free advertising.
Mm-hmm. I'm here for you.
Okay, we have time for one or two more questions. So let me see. There's definitely a lot, and it's great to see so many questions here. So this one is in relation to your last point, which is, can the executor be charged with digital fiduciary to close all online accounts for the deceased?
Yeah, that's a separate document, so you can name whatever representative that you like for that. But just remember, with all of the documents that you want to prepare, and I'm going to just bring this back real quick. Just bear with me for one quick second. So all of these documents that you need to have that I had mentioned, you definitely can name different representatives for each one of these. They don't have to be the same. So remember, the digital fiduciary is another box that would be added to this, but each one of these could be a different representative. That might create a little bit of a headache. I don't know. It depends on the situation, but they very well could be, or it could be all the same person. That's completely up to you. The one thing I know for a fact is I would never name my sons as the healthcare power of attorney because I don't really trust them in that capacity. But that's just me, because I have a daughter. So of course I know she's going to take care of me better in that, but that's just my opinion.
Okay. And then here's one more question. How do I handle real estate in a foreign country and ensure title is passed to my heirs, other than, I guess, observing the foreign country's intestate laws?
Yeah, that's a tough one because it depends on the country. And I mean, it falls into the area of agreements that the United States has with that particular country. That also holds true from a taxability standpoint and an estate standpoint. So right now, if you look at, as an example, the income, there's a universal income system for income taxes. And so, you know, basically how it works is if I have income and that I earn in one country and I pay taxes there, but if I paid less taxes there than I paid in the United States, then I'd have to, if I bring it back to the States, then I have to make up the difference here. So that connection just depends on what the laws or rules are between those two countries. So it would have to be very specific.
Well, thank you so much, James, for both your presentation and this very robust Q&A session. I'm sorry we didn't get to everyone's questions. We will, as I said, have this recording available, and we will check with James to see if he's comfortable sharing this slide deck with you.